2022 Annual General Meeting. Before we go any further, I'd like to acknowledge the traditional custodians and owners of this country, the ancestors, the country. We are Gadigal country that was never ceded. Those of us who come to Australia as refugees need a way of connecting to our new country. And it is Australian First Nations, the custodians of the country, that can help us make this connection. And that goes for me as someone with lived experience as well. So again, I acknowledge the Gadigal country and pay my respects. Before we go with the business of the annual general meeting, I must not have introduced myself. I'm the president of the Refugee Council of Australia, and my name is Jasmina Bajraktarevic-Hayward. For those of you who cannot read tiny writing next to my next to me. Before we go with the business of the annual general meeting, we'll have our guest speaker, Minister for Immigration, Mr Giles, and I shall introduce him, and then we have some questions that people have sent in to us. So Andrew Giles has served in federal parliament since 2013 as member for Scullin in the northern suburbs of Melbourne. From 2016, he served as a shadow minister in portfolios including schools, cities and urban infrastructure and multicultural affairs. After the election of the Albanese government in May this year, Andrew was appointed as the Minister for Immigration, Citizenship and Multicultural Affairs. Prior to his election to Parliament, Andrew was a principal lawyer at Slater and Gordon, practicing in employment law. He has also worked as a lawyer at the firm Holding Redlich, where he acted on behalf of the asylum seekers from Tampa, and in a number of political roles for the Victorian government. He has been a member of the ALP since he was 18. And Andrew, we know that you're married to Dr. Gillian Constable, and you have two children, Daniel and Alice. Over to you.
Thank you very much, Jasmina, and I join you in acknowledging the Gadigal people of the Eora Nation, the traditional owners of the land that we are physically gathered on here in this boardroom. I pay respect to elders past, present and emerging, and recognise the lands of all the people joining us on this call. Can I thank you and RCOA for having me along at the AGM. It's a pleasure and a privilege to be invited as Minister, having had a long-standing engagement with the Refugee Council through my time as a Member of Parliament. I have appreciated the opportunity to engage informally with those of us who are in this room now, and it is important to me that I continue to engage with the Refugee Council and its members as I go about doing my work. I've had a brief discussion with the President and the CEO, and I think the time that's available to us is much better served with me engaging with the questions, because I know there is a very large number of questions that people put forward rather than me setting out opening remarks. So with that, I might pass back to you, Jasmina.
Well, Paul, our CEO, has got a collection of questions, so Paul, over to you.
Thank you, Jasmina. Thank you, Minister. We invited people who RSVP to the AGM to submit questions in advance up to yesterday evening, and so we actually have 18 questions to start with, which covers, in fact, the broad range of issues that have been raised with the Refugee Council. So I'll just go through. We'll go through topic by topic. There's probably, unfortunately, a limited opportunity to, if any, to raise additional questions, but I'm sure those of you who are online will probably have the key issue that's in your mind covered in the questions that have been raised, because there's been such a comprehensive range. So the first lot of questions relate to temporary protection visas and safe haven enterprise visas. So we received two questions about access to permanent visas and also one about procedural fairness for people whose visas were rejected. The first question was from Satara Sharifi, who's a member of the Queensland Youth Parliament, and Satara asked, right now the Hazara genocide is happening in Afghanistan, but the continuous impacts of genocide are being felt in Australia as well. There are thousands of people from Afghanistan currently on temporary protection visas, and they cannot bring their families due to the lack of a permanent visa. The ALP government got elected because of their commitments, and one of them was that they will end TPV and SHEV visas. Can the Minister say how and when he's going to end this disaster? The second question on a similar theme was from Roxana Zulfikar, and she asks, when will temporary protection visa holders be offered permanent visas and what will the process be?
Sorry, Paul, but you have a screen share issue
Yep.
because we are
I've just asked the
invisible.
IT guy to come. Sorry, someone's managed to share the screen.
Right.
Okay.
So people can't see us, but they can see screen share. So we
Okay,
know
I can't
audio
hear.
only.
We know if they can hear us, we'll probably keep going.
They can, yeah,
here we go.
we're going
We're
with the
back.
audio. Okay, we're
Okay,
good.
so fix it.
We can
Okay.
hear, yeah, you can hear us?
Good.
Okay.
Sorry. Paul.
So the third question related to TPVs and SHEVs is about procedural fairness. So this was from Hussein Ahmed from the Imam Reza Welfare Association, and he's asking a question on behalf of members of the Parachina community from the Pakistan-Afghanistan border. And so he's asking you, Minister, what the plan is for asylum seekers who arrive by boat. The concern of people from that community is that their cases were refused unfairly, and then they've have great difficulties with the Immigration Assessment Authority process. They've been waiting for a court hearing for 3 or 4 years. So the question is there any hope for people who have been part of the TPV and SHEV group who've had their cases rejected?
Thanks, Paul, and I thank the 3 people for these questions. I want to be clear about a couple of things. Firstly, as a government, we're committed to doing everything that we said we were going to do in our platform and our election commitments. And for me, there is no more significant commitment in my areas of responsibility than dealing with the issue of temporary protection, ending temporary protection and giving people entitled to protection, permanent protection through that cohort. Now, I want to be clear also in saying that I can't preempt government announcements today, and I'm sure that will cause frustration in terms of my inability to provide a detailed answer to those 3 questions, but I should be very clear about that, as I have been at dozens of forums over the last 4 and a bit months since I've been the Minister. I will say this though, that I have taken the time to go around the country to meet with TPV and SHEV holders and applicants, particularly members of the Afghan community around different parts of Australia, to listen to their concerns, to bear witness to their experiences, and to recognise that this issue of the bar that has been in place around family reunion is a particular element of cruelty that I think is often not recognised in terms of how this regime has impacted the lives of many thousands of people. I can't give a timeline, and nor would it be appropriate for me to work through the details of the approach that we will be taking to effecting transition. That will be announced when it is announced by government. But I can say that in all the discussions we have had with lawyers, with advocates, with experts, I think there is a very large degree of unanimity around the sort of approach that should be adopted and how that approach could be given effect to. In terms of the issues around fast track, again, the failures of that process are matters that our platform does go to. Those concerns are real, and they are matters that we are giving thought to prospectively, as well as in terms of how we manage the immediate issues that are before us in terms of resolving the TPV SHEV cohort.
Okay. So just from the point of view of the people who've gone through the fast track process and have felt aggrieved about the outcome, will there be, when the government makes its announcement, there will be consideration for their situation?
Well, I'm not going to preempt the government's announcement, Paul, but I will say that we are concerned, I am concerned about the fairness of the fast track process. That's a matter that's set out in Labor's platform.
Great, okay. The second lot of questions relate to offshore processing. So the first one was about the situation in PNG, and it came from Mardia Simpson from the Stop the Shame group in Shoalhaven. So she's asking, what are the Australian government's long-term plans for the refugees and asylum seekers currently stuck in PNG? And could you comment on the present costs to Australia of maintaining this PNG facility in comparison to facilitating the resettling and making a life of freedom for these people?
Well, I should be clear and say that these offshore matters are not within my portfolio responsibility, so my comments are general, not specific, and obviously people will appreciate that we no longer have the direct engagement with the refugees and people seeking asylum in PNG that we used to that we formerly had by reason of the PNG Supreme Court decision, amongst other things. I have been speaking regularly, however, to the UNHCR about the circumstances of that group of detainees, and it is a matter of ongoing concern to me, but I have no direct responsibility for that group of people.
Okay. Well, the second question was about people who are waiting for US resettlement. So there's been no recent information about the 200 or more refugees who have provisionally accepted been provisionally accepted for resettlement from the United States. I'm sorry, I should mention this question is from Mary Edmonds. Those who remain in Australia have no visas, are not allowed to work and have very limited access to services. So can you clarify what is happening for them? And if they wish to remain in Australia, do you offer them any prospect for that?
Again, in terms of this, I want to clarify that not within my direct portfolio responsibilities, but this, I do feel I need to clarify that the government's position is that people in that cohort should be looking to progress their resettlement options either to the United States, and perhaps I might be able to get some better data while I'm here about the progress of that outstanding group, which I didn't think was that large, but I'll check that, but more particularly to New Zealand. And I know a big focus of the work of my colleague, Minister O'Neill, is on dealing with that group of people who are on Nauru in that respect to ensure that they can rebuild their lives with durable resettlement options in that country.
So in relation to the New Zealand arrangement, is there anything that we should be expecting in the near future, do you think? Or?
Well, again, I'm not going to speak on behalf of Minister O'Neill's in New Zealand at the moment.
Okay.
It obviously is a priority of our government.
Okay. So there are two questions about ministerial intervention. So the first one is from Malcolm Dunning from the Indooroopilly Uniting Church Asylum Seeker and Refugee Support Hub, Brisbane. So his group has been involved for the past couple of years in supporting a family who are stateless, who are from Iran. They're working in a regional Queensland town. They've submitted a request for ministerial intervention to allow them to apply again for a protection visa. And in May this year, they received a letter from the Department of Home Affairs advising that their request had met the guidelines for referral to the Minister's Office for consideration. And since then, they've had no reply from the Minister's Office or from the Department. So do you have a timetable for consideration of outstanding ministerial intervention requests? And yeah, I mean, what's the situation? Is there, or are you waiting for to develop new guidelines for ministerial intervention? Is that a factor in any delay? So, and if you are, so we're also interested to hear any timetable for a review of ministerial intervention.
Yeah, so on the last point, I am looking at the guidelines for ministerial intervention at the moment, and we can chat further about that over the course of this discussion or down the track. But that's a matter that we are looking at. That is not delaying my ministerial intervention responsibilities. I should say, in respect of the specific question, I just want to be careful because I should not be commenting on any individual cases, so I won't comment on this one. But I'll say to Malcolm, if he's authorised to act on behalf of these people, if he wishes to write to me, I would be able to respond to him if he has that authorisation. I think people would appreciate I can't and most definitely should not if those circumstances are not met. I can say a couple of things more broadly about MI. Firstly, that there was a very, very large volume of matters, requests for ministerial intervention awaiting me when I became the minister, and I've been working my way through them. I've additionally been looking particularly at long-term detainees in this regard, and I think people around this table would know that we've made several hundred decisions in those circumstances. These decisions often are complicated decisions, and all of them require the consideration of a very large volume of material. Each person's case deserves to be treated on its merits, and I'm required to have regard to all the matters before me, which often amounts to many folders of material. So these decisions sometimes take time. It's important, however, that I take that time and that I make decisions that are correct in the public interest and in the interest of the person, the subject of the intervention application.
So I suppose just a little more about the review that you're undertaking. I mean, what was it, that you felt needed reviewing for the way in which ministerial intervention operates?
Well, not every request for ministerial intervention finds its way to me, and that is necessary. The question I have is, are all cases that might warrant intervention being steered to me for beneficial decisions through the guidelines? And I'm working my way through, as I've done now several hundred decisions and considered others that haven't found their way through, as to how I can make sure that those matters that are most urgent, that are most deserving, are finding their way to me. That is a complicated process, and I want to ensure that we have guidelines that are fit for purpose and do an effective triaging job as well. And that is a bit of work that's been underway really since very shortly after I became the minister. But I want it to be informed by my experience of making use of the powers that I have under the Act, and my understanding of the volume of work and where cases that I feel are deserving of close consideration have not been finding their way through to me.
Okay. And also, just what's your personal assessment of the powers of the minister now that you're in the role? Because there's obviously been discussion over the years about whether they're too great or appropriate or whatever. So what's your...
Paul, that's a really important question, and I think one that should be the subject of much wider public debate. Minister Evans spoke and wrote about his concern about the broad scope of his powers. And that's something that I've thought a lot about before I was appointed to this role, and I've thought about much more pointedly since I have had this role. I think there are 2 points that need to be made. Firstly, I think there is often a high level of misunderstanding about the confines within which intervention powers can be exercised. There seems to be a view in the community that I can exercise them at large to do anything in the immigration system. That is not the case. And a number of people who write to me seem to think that issues, including the resolution of the TPV Chev cohort, can be resolved in that manner. That is not the case. So there's an issue of perception. Then there's the issue of whether the scope of the discretionary power is appropriate, and I think that's a really important debate. My view is, looking at the work that I have been doing around long-term detention, is I think there is a really important role for discretionary decision-making. The more I think about this, and I'm not an immigration lawyer, the complexities of the Act, the complexities of the regulation, the importance of migration decisions to the lives of people, not just refugees, but everyone who uses this system. And I'm conscious that since I've been the minister, which isn't very long, we've made 3.3-ish million decisions. The volume of decision making is enormous, and the significance for people's lives is enormous. I know this is the most litigated part of government. I'm the most sued person in Australia, and as case law evolves, that often brings forward difference of approaches and different consequences. So I think there is and will have to be a very significant role for discretionary decision making to deal with injustices in particular cases. But I do think we need to have a wider public debate about how that can be understood, how it can be applied, and whether there needs to be more constraints or guidance about that.
Okay. Well, the second question related to ministerial intervention was from Catherine Russell, and she says that prior to 2022, asylum seekers on a bridging visa were given an open-ended bridging visa E when waiting for a response to a request for ministerial intervention. But since early this year, those on bridging visa E sending in a ministerial appeal have only been granted 3-month visas while they wait for a response. And this makes it very difficult for people to find jobs, as employers are reluctant to employ people on very short-term visas. So with no access to Centrelink, this is reducing a cohort of people to unnecessary poverty and stress. Could the Minister restore the previous model of an open-ended bridging visa until the ministerial intervention request is dealt with?
I'm just going to check with my staff, but I don't think this is right. Yeah. Most people do get open-ended bridging visas.
They're not indefinite, or they didn't used to be definite, they were just rolling.
Yeah.
Is that what?
Okay. Well, what we could do is we could actually communicate with Catherine and
I think we can, because it's not right.
Yeah, okay. All right. But in terms of what would your view be as to what's reasonable?
Well, I guess a bridging visa, whether it's E or whatever, is simply a device that keeps someone lawful when they would be otherwise unlawful. So it's very difficult to give an answer that covers the field. I've made a number of decisions around granting people BVEs for a whole range of different circumstances, and there sometimes is a reason to make it 3 months, but often there isn't. And I make my decisions in accordance with the law in regard to the relevant circumstances, but the assertion contained here is not an accurate statement of the position.
I think there's also a lot of stress in the community about bridging visas expiring, and often the Department of Home Affairs will be the most relaxed about the expiring of the visa, but the person involved...
Just to be clear, I'm not relaxed about that, and I'm not relaxed about the consequences of someone unnecessarily becoming unlawful, and that's something that goes to every decision I make, which results in the grant of a bridging visa. No, sure, that's good to hear, because the person whose visa has run out against their wishes, and the person who employs them, if they're working, are often very, very stressed about that. Okay, the next question is about the Status Resolution Support Services Program, and unsurprisingly, it's actually come from Cumberland Council, from Hollywood, as one of the communities most affected by the issue of asylum seeker support. So Cumberland LGA is home to the greatest number of asylum seekers in Australia, Holly says, and also has one of the highest levels of disadvantage in Greater Sydney based on the CEFA index. Asylum seekers also have far fewer government services available to them and must rely on local charities. So will the Minister support increased access to the SRSS program for those waiting to have their refugee application assessed by the government? A few things here. Firstly, I should acknowledge that there's a Cumberland councillor in the room. Secondly, my friends in the cities of Fairfield and Dandenong would probably have an argument about need, but that's probably beside the point. We have got some platform commitments around looking at support for people seeking asylum more broadly. It's something that I've been giving regard to right now as I'm engaged in the settlement review conversations with the sector. So that's a bit of work that is underway. I certainly hear the concerns, and I'm particularly conscious of the concentration of need and its relationship to often the provision of wider social and sometimes economic infrastructure that I think this notes that is less than in other communities. So this is an important question to me. It's part of the work that we are doing as we review settlement services more broadly.
Yeah, and I think it's interesting that the concern about the impact of lack of access to support for people on bridging visas is being felt very, very keenly amongst member organisations of the Refugee Council who are involved in frontline support, but also local government and state government has become very actively involved, and you'd be well aware of the work of the Mayoral Task Force on this issue, and also state governments, our organisation and New South Wales-based organisations like the Asylum Seeker Centre, JRS, and the House of Welcome been lobbying the New South Wales government, which was actually fairly reluctant to initially to get involved in supporting filling a need that the federal coalition government had created. But they actually have come to the party, quite generously over the last 2.5 years, and they've just extended support through their emergency relief program through to June next year. So they've announced $3.65 million additional funding. But it was clearly on the understanding from their perspective that things are going to change next financial year. So will things be different in 2023-24 for support for asylum seekers in the community than they have been in recent years?
Yeah, well, this is a common theme, but I can't preempt decisions that will be part of the budget. So we are now moving towards the May budget. These issues I have been discussing. In fact, I discussed them this morning with the New South Wales Minister, Minister Kure.
Oh, great.
I've discussed them with my colleagues in the Victorian government. Just about every local government that hosts refugees has raised this with me, as have many of the organisations like the ASRC and others that are involved here. As I say, these are matters that we are currently having regard to.
Okay. Yeah, I mean, because one of the questions that we and our members are grappling with is whether to focus on reform of the existing program or whether or not there's a need for a substantially different program. I mean, there seems theoretically to be quite a lot of flexibility potentially in the SRSS. I mean, do you have any view on that, or are you still forming a view?
I've got an open mind about it. I mean, I know there are different people of goodwill have differing views on how best to achieve support and how closely it should be lined up with how we deliver other aspects of settlement services. I've got an open mind about it, but I do, I am of the view, and we are of the view, that the supports that have been provided have not been adequate.
Yeah, and we've seen a 94% cut in assistance given through the Services Australia to asylum seekers over 6 years, so it's been massive. Yeah. The next couple of questions were about Indonesia, the situation of refugees there. So Nitsa Siano asks, I'd like to know when our government intends to work with the Indonesian government on creating a safe pathway for refugees from Indonesia to Australia with the involvement of UNHCR, and that this is in Labor's platform. The Prime Minister is in Bali right now and has the opportunity to raise this issue. Also, why does the issue of refugees always appear to be the elephant in the room? Muzaffar Ali from Cisarua Learning asks, we've seen an increased number of refugees being resettled from Indonesia and refugees who arrived before July 2014. But unfortunately, this does not include refugees from Pakistan. Will the government change its policy to resettle refugees from Indonesia who came after July 2014? And also will refugees from Pakistan be included?
I mean, in terms of, there's no change in policy currently contemplated. I wasn't aware specifically of the Pakistan question, and I'll take that on notice and through you get back to Muzaffar, Paul, if that's all right.
Yeah, sure.
In terms of Nitsa's question, our engagement with Indonesia more broadly on these issues is very important, and our platform sets out our desire to work in a way that recognises that forced movement of people in our region is not an Australian problem. It's a problem that Australia needs to play a constructive role in helping to solve, in the interests not just of Australian politics and whatever we think from moment to moment, but recognising that other actors, Indonesia, Malaysia, all regional countries, have their own perspectives, and we need to work harder to bring those perspectives together. The Bali process obviously at various times contemplated this more directly. We have got some thoughts around how that will be prosecuted. I haven't had the chance to speak to the Prime Minister about his engagement while he was in Bali, or indeed I believe he's now in Bangkok. But our sense as a government about the importance of a constructive regional partnership around safer pathways is something that's very important.
Okay, and just in terms of safer pathways within the region, I mean, we've discussed previously, that's a pretty core part of the, well, that's spoken of in some detail in the ALP platform. I mean, what's your thinking about how the process of change happens?
Yeah, well, I think we've got to recognise that we must treat our regional neighbours as partners, not in a transactional sense. That's the first point. And while obviously I'm very committed to this element of our platform, this has been our platform for a couple of election cycles, it can only be effective if it's something that happens with the cooperation and in the interests of particularly Indonesia, but the other significant transit countries in our region. That is obviously a big bit of work. It requires us to engage constructively and openly, and to recognise that this is not a conversation that's about our interests. It's about our concern for people
Sorted it.
Can you hear us again now?
Yep.
Yeah.
Great. Okay, well, the next question was about the offshore humanitarian program. So Roxana Zulfikar asked a question, which is, will the priorities and intended composition of Australia's offshore humanitarian program for the current financial year be publicly released? And if so, when? Because this information would greatly assist refugees to make informed decisions about whether to lodge humanitarian visa applications.
Thanks, Paul. The first decision I made when I became Minister for Immigration was to release someone from detention. The second decision I made was to ensure that our program is non-discriminatory. And so you will see a program that is informed by our advice from the UNHCR as to need, and it will include those cohorts that had been excluded, people from a number of African countries, non-religious minorities from the Middle East, and Rohingya as well. It will be out fairly soon, I imagine. And I thank everyone, including a few people in this room, for their involvement in the consultations around the program. So hopefully that is a good guidance note, and I imagine that these details will be available in greater detail soon.
Okay, and I suppose just further on the offshore humanitarian program, I mean, I think everyone online is well aware of the commitment in the party platform to a program of 27,000 plus 5,000 additional community sponsorship places. So what's your thinking about that now you're in government?
Yeah, look, I mean, I think it's the most significant commitment that we make in this area, to go to 27,000, but also to 5,000 additional community sponsorship places. We are currently working our way towards timescales to get it to 27,000, thinking about the settlement services part of the equation as a really critical block, because at the moment there's a need for a bit of capacity building in order to deal with a significant increase. Obviously the Afghan intake has shown us how stretched we are a bit at the moment, so we've got to do these two things at the same time. I am working towards a body of work that gives us a time frame to get to the 27,000. I'd like it to be as soon as possible, but there are two caveats there. One is our capacity to do the settlement work. The other one is at my capacity to persuade my colleagues of the timeline, noting that obviously it carries quite significant implications for government.
Okay, great. Well, I think all of us can suggest areas where the department might be able to save money, particularly in the offshore processing area, to support a large program. Speaking of areas where there's possibility of saving money, I wanted to talk about immigration detention. We've got a few questions. So the first is from Gerald Mikuibi Magala, who's on behalf of humanitarian and protection visa holders at Fiddlewood Detention Centre. So he's saying that Australia has ratified the UN Convention under which the government has non-refoulement obligations. Why are protection and humanitarian visas cancelled under Section 501 and the visa holders placed in detention? Do the detention centres become their new home since they can't be returned to those countries that are being protected from? Maybe just ask that one first.
Yeah, well, obviously we now have under the Act a mandatory cancellation regime for non-citizens under certain circumstances. So that's the why bit. I think the more important focus is how do we deal with the consequences of that, particularly for protection visa holders, or former protection visa holders, I should say. of whom there aren't that many in the immigration detention network at the moment. I have focused in my time as Minister on looking at reducing the number of people in immigration detention and have a particular focus on people who have a refugee or asylum seeker background, with a particular focus on those who have been in immigration detention for a long period of time, with another lens being people who are not capable of being returned due to non-refoulement obligations. And people in the room may be aware that a very large number of people have been released from immigration detention in that time. I'm working my way through that bit of work, noting that not everyone will be in a position to receive a beneficial decision because of the nature of their circumstances.
So maybe a follow-up question to that. I mean, the department always used to say, and I'm not aware that it's changed, is that immigration detention is administrative detention for the purposes of status resolution. I mean, we're now at a point where the average length of detention is well over 2 years, and there are quite a number who've been in detention for 7, even up to 13 years. So, I mean, what's the current thinking about the role of immigration detention? And and in terms of as many of the people who are currently in detention have served some sort of sentence, sometimes not a custodial sentence, sometimes longer custodial sentences, they've actually served their time. What's actually, what's the purpose of immigration detention if it's no longer focused on, a short-term detention to resolve people's status?
Well, that is its focus, but the reality is that is not how it's been operating in practice, and in part that has been because of the punitive attitude to the former government. In part that has been due to the challenge of COVID around returns for people who could be returned, and the fact that many have been returned and others have been released has pushed that average length of detention up in a way that is obviously strictly accurate, but I think slightly misleading in terms of how the cohort is functioning. I think one of the big issues that we have dealt with as a government is to have regard to the ministerial direction that operates in respect of the cancellation regime, and have had close regard, particularly on the basis of discussions with our friends in New Zealand, about how this can operate in a way that better reflects our obligation to people who've spent the majority of their lives in Australia as opposed to another country. That is one of the ways in which we have been considering how this visa cancellation regime can operate more in the manner in which it was conceived of, and there is further work to be done around other aspects of that, including having regard to those issues of non-refoulement and some complicated issues around the prioritisation of some other concerns that family violence is often raised with me. So looking at how people do find their way into immigration detention, and again I'd say that almost all of those who find their way in at the moment are not from refugee or asylum seeker backgrounds, whilst having a very close look at the long-term cohort, which, as I say, has been one of the principal focuses of my time in the role.
Yeah, I mean, just on that question of, the numbers, of refugee background in detention, we've been asking the department about that, and recently, I think the figure, if I remember correctly, was 279, out of 1,300, but still, have had a refugee or humanitarian visa or applied for one at some point. I mean, what we also see is that some figures that came through as replies to Senate estimates question show that in terms of average length in detention, Afghanistan, Iraq, Iran, and stateless people and Sri Lankans were at the top of the list in terms of the length. So it sort of highlights the fact that the length of, even though the numbers might not be as large as, UK citizens or New Zealand citizens or the like, that the length of detention, because there's nowhere to go, is greatest for those who come from countries where it's unsafe for people to be returned. So. Yeah.
And that has been a focus of my engagement, and not just with pen and paper, but in terms of visiting our detention facilities and hearing directly from people in immigration detention.
Okay. Well, another question about alternatives. So this comes from Sanyo Sualio. In the Australian legal system, there are reprimand options like interim control orders, community correction orders, good behaviour bonds and ankle monitors. These help offenders to rehabilitate and seek more professional help to mitigate their offending behaviour. Aren't there options to mandatory cancellation of visas for holders with less serious offences? And why is the review process creating long waiting periods and ultimately indefinite detention?
Yeah, I mean, we are doing a body of work informed by the oversight bodies who and our experience in other jurisdictions looking at alternative arrangements to health detention. That's an important bit of work, and all of these ideas are significant ideas to explore. I'm more sympathetic to some than others on that list of three. One in particular I'm not particularly disposed towards, but I think it is important that we work our way through what alternative arrangements are in place for what is administrative detention.
And another question on immigration detention centres. So the management of these facilities has become managed more like prisons by the Australian Border Force. So is the government going to review how immigration detention centres are managed?
Well, I think we're having a big look at the operation of immigration detention.
Yeah, and one significant cultural thing that we've noticed that's changed has been, the constructive role that community visitors played in the immigration detention centres in the past. And as the visiting procedures have become more restrictive, and the requirement, the possibility of community groups visiting and even reaching out to people who may have no support at all in the community has been very much restricted, not only because of COVID, but even prior to that. So I encourage you to look at the role that, the important role that community visitors, particularly, in informal community-based groups play in providing support to people in detention.
That is an important issue, and I speak as someone who has been visiting in various capacities immigration detention for probably 21 or so years, and obviously I've noticed the changes. Some of those changes go to management. Some, I think it is important to acknowledge, go to some of the compositional questions of the detainees, which raise issues that do need to be grappled with in terms of the safety of the overall detainee population, which are complicated to resolve. And that goes to some of the debates about what regimes around powers and oversight are applied to these facilities. And I'm concerned to work through that piece of work in consultation with all those affected, but particularly with the oversight bodies, to ensure that the network is operating as it should operate, not how it has always operated.
Okay. We've got two questions related to the onshore protection process and work rights. So the first from Mandeep Kaur. Does the Labor government have any plan to give an amnesty to people who are seeking asylum in Australia and whose refugee claim is unresolved? And a question from Shamla Pillay about work rights, about the situation of people who've been denied work rights, even when they've been very open with the Department of Home Affairs about the situation. So, on what basis? And the core of the question is what's an acceptable reason for the denial of work rights? And what's your view about work rights?
Well, there won't be an amnesty across the board. Okay, I can answer that one directly. The work rights picture again is complicated, and people will be aware while there's heated debate about the extent to which it is happening. Or how it is to be addressed, but I don't think there's any debate that there has not been significant people trafficking into Australia, and people reading the 9 newspapers and watching 60 Minutes would have seen some illustrations of that. So I just, that recognising the practice of exploitation through people trafficking is for me not only an acceptable but a necessary reason in some circumstances to restrict work rights. My broad view is that otherwise, people who are able to work should be supported to work. But I just make that point that there have been very significant revelations about people trafficking, not for the first time, that require consideration in looking at this question.
Well, just related to that, this was a question from me about, this, the media coverage about the visa scams that have brought 100,000 workers into Australia using false claims, as the newspapers put it. Yeah, I'm interested in your thoughts about that. I mean, the Refugee Council and quite a number of organisations in our network were quite concerned that the claiming of asylum was being lumped into visa scams without any qualification, and we're pretty concerned about some of the public comments that Abel Rizvi was making in relation to that, because it appears as though he's not making any distinction between people, with protection claims which need to be examined, and people, who may be using the delays in the systems to remain in the country when there's, not a strong case for them to seek protection. So when we look at the this figure of 100,000, well, we actually see there was 96,000 in the onshore protection caseload, of whom around 70,000 are waiting either for a decision from the department, so there's about 26,000 waiting for an initial decision. There's another 38,000 waiting for a decision from the AAT, and there's several thousand, perhaps 3,000, perhaps 6,000 waiting for judicial review. So 70% of that group of people are waiting for a decision from from a government authority or a court. So and I suppose one of the concerns, is that this review, if which the government has begun, if it examines the issues in the way in which they're being presented in the media, there's actually significant threats to the onshore protection process. So what's your thought about?
Look, I mean, I actually think the contributions of Abel on the one hand and people like Hannah Dickinson on the other aren't actually diametrically opposed. I think everyone recognises that there are issues that go to the trafficking of people to Australia for work, and its consequences for those individuals and the labour market more broadly that are significant challenges for government. I strongly agree with you that one of the real, perhaps the nub of the challenge, is to recognise the significance of delays in our system in incentivising these sorts of work right abuses. These are things that need to be addressed. And obviously, or perhaps not obviously, that's the issue, not questioning the human right to seek asylum. That shouldn't be questioned. But I think we need to find ways to enable the efficient resolution of claims which are on the face of them meritorious, of which there is significant evidence in particular cohorts, in a way that is consistent with our international obligations and the rights of those litigants. That's a really important piece of work. But the other important bit of work is just the administrative one of having a process of review and assessment that is speedy.
Yeah, 90 days perhaps, as the
AAT suggests. But it's actually the AAT that's the rule back long.
Yeah. So what's? I mean, we've heard the comments, and maybe this is. In fact, I can probably guess what you're going to say. But the Attorney General has said, has expressed his concern about the AAT, and and obviously, we would support reform of the administrative review process. But in the short term, the AAT's got no resources. In fact, I understand fewer resources in the most recent budget, or it's gone either nowhere or backwards. And so the problem still remains. I mean, what's the government's thinking about the AAT?
Well, I talk to the Attorney General about this often. It's clear that he appreciates this problem, which is not the only problem that impacts the AAT, of course, but it is very significant. It has quite wide-ranging consequences. And I'm concerned that in addressing this issue, we don't open up some of the concerns that you are articulating. That is something that is very important to me. I just think we need to find the balance between accepting that there is a problem that government needs to deal with, and to addressing that problem in a way which is consistent with our broader approach to meeting our obligations to people in need of humanitarian protection, and also lining that up with the commitments that we have made. I think everyone would like to see that protection claims be dealt with expeditiously as well as promptly, and where they are subject to review, that review process also be quick.
Sure, and certainly reduce the room for people to remain in the country long term, without a
Bridging visas or otherwise.
yeah. So I have a question from Nikki from Little Universe Films, who's asking about family reunion. So the delay in processing of applications. So some people are waiting 4 years and still haven't had a response. So is there any plans to review how the family reunion program works?
Well, family reunion, we're a majority migrant nation, so family reunion is an absolutely vital part of our immigration system. We've put quite a bit of focus on that in its interrelationship with our humanitarian program and obligations more broadly, particularly with regard to looking at opportunities for people from Afghanistan. That obviously is a very long time, and I might ask if Nikki wants to perhaps contact my office.
Okay, so John Rock, who's actually on the board of the Refugee Council and is from the Australian Korean organisation. So he has a question. He says that his organisation welcomes, and the Myanmar diaspora welcome the provision, the government's approach within onshore processing for asylum seekers from Myanmar, the priority that's been given to them. But in relation to the offshore program, there's a huge number of vulnerable people within Myanmar, 1.4 million IDPs, and there are also 1.2 million refugees outside of the country, within Southeast Asia and South Asia. So what provisions are you making for the protection of people from Myanmar?
Obviously, engagement with Myanmar more broadly has been a big focus for the government and the efforts of Senator Wong in recent times. And as an Australian citizen, I was very pleased to see the news this morning about Mr Turrell. Again, I'm committed to Australia having a program that is non-discriminatory and that enables people to be resettled on the basis of need as determined by the UNHCR.
Okay. I've got a question about the citizenship test. So, and I'm prompted to ask this question as raised by members of the Yazidi community and their supporters in Armidale. So in Armidale's Yazidi community, has been there for around just over 4 years, and so the first community members are sitting for and passing their citizenship tests. However, older adults who are not old enough for the age exemption, who are desperate to become Australian citizens, are being left behind. So because their English is not yet good enough to pass the test, they would be happy to sit the test with if they could be assisted by an interpreter. And I think this opens up the question of, why would Australia reject people who are really keen to become citizens of the country? So I'm interested in your thoughts about the citizenship test and about Australia's approach to citizenship.
Yeah, well, I think this has to be my last question, so I'm
Yes.
told that I'm being picked up now.
Right,
Which,
okay.
but this is a really important question, and can I say my very strong view and the government's strong view is that we as a modern nation have been built not just on migration but on migration as a pathway to citizenship, and that's been eroded in a range of ways in terms of how our migration system operates. But the frustrations in people being able to complete their journey to full participation in the Australian society are something that I'm very concerned about. I'm concerned that it particularly impacts some refugee cohorts, people from Afghanistan, people from Myanmar being the two standouts. We have focused on looking at that group of people who have been waiting for their citizenship for more than a number of years, and I'm very pleased that backlog has gone down by more than a third. We're working our way through it. Now, moving to the question of the test, I am concerned that the level of English language it requires of people is too high. And a person's capacity to speak English at that level is no guarantee of their commitment to this country and its values. So that is a matter that we are working our way through as a government. I think We know that there are a number of cohorts who feel particularly concerned about it, and I feel very affected by the fact that there are reports from the people who do this work, that a number of people, and I'd say older women from a couple of Middle Eastern backgrounds in particular, who keep cancelling their test appointments clearly because they are so scared about not passing. And that is just awful.
Yeah.
That is just awful. People who've been through trauma, who want to feel safe, who want to be a full member of this society, being denied that opportunity and re-traumatised for absolutely no reason at all.
Yeah.
So this is something that
And even more so when other members of their family are passing their tests and they're left behind.
Exactly. It really is. Yeah.
Okay, great.
Yeah, thank
Well,
you.
thank you, Minister. You've been really generous with your time. So,
Thank you.
and we wanted to give you a little token of our appreciation to share a meal, share a story. With the Refugee Council of Australia. Thank you.
Thank you very much, everyone.
Thanks.
Run downstairs.
Thank you.
Thanks, Paul.